Beyond the model rules, there are professionalism guidelines in most jurisdictions, including the federal courts. These guidelines are aspirational. They are enforced generally only by peer pressure. If a client is abusive, if a client is bullying, if a client is making demands that you know you can't fulfill and then they're complaining about it, your own attitude toward the client is bound to infect the way you represent them. Professional courtesy is not a weakness. Professional courtesy is a way of ensuring that you are best able to represent your client because you have an appropriate reputation in the legal community and with the courts.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Richard Hunt. Richard is a Texas board-certified civil trial lawyer with more than 40 years of experience representing businesses and individuals in litigation, arbitration, and mediation. His practice focuses on complex civil litigation and on the disability rights provisions of the Americans with Disabilities Act and the Fair Housing Act. The webinar presentation that you're about to watch will be approximately 1 hour, and Richard will be taking questions from the audience, time permitting, towards the end of the webinar. So if at any time you have a question, you can submit those by clicking the Q&A button in the control panel at the bottom of your screen, sending them in there, and we will get to those once the presentation has wrapped up. Now, without further ado, here is Richard Hunt to discuss dealing with drama, staying ethical and professional with challenging clients and counsel.
It is a pleasure to visit with you guys. Dealing with drama is not a new topic. It's common for lawyers my age to talk about the good old days when our opposing counsel were inevitably fair and our clients paid attention to us and were polite and paid their bills. But the truth is, in my first year of practice in 1981, I had to deal with a local lawyer here who was notoriously rude and disrespectful to other counsel, to the courts, and sometimes to court personnel. And at that same year, I had to deal with a couple of clients who would not take my advice and would not pay their bills, and who fortunately weren't really my clients because I was a young lawyer. But the problems we're going to talk about have existed as long as the adversary system has existed, or probably as long as people have been interacting with each other in bad ways. So there is something to learn from anybody, for everybody rather, young or old, about ethics, and what is true now has been true for a long time. What are we going to do today? First, we want to understand the rules and guidelines that as professionals we are bound by. This is the necessary background for talking about difficult clients and difficult opponents, because our actions are constrained by those rules. We also want to understand how to develop a strategy for dealing with difficult situations. I hope today will come away with some ideas about how to be prepared in advance, either to avoid situations that are problematic or to deal with them if they come up. We're going to talk in particular about communication with difficult clients. Communication is a critical skill for lawyers, but it's also a critical professional obligation for lawyers. And our clients are frequently, will frequently complain that they don't get sufficient communications. And then, as I said, besides a strategy, there is planning in advance. We're going to start with difficult clients because if you're a lawyer, you have clients. The ethical rules that govern our relationship with our clients are mostly found in ABA Model Rule 1.x. They're usually at the top of the list of any state's disciplinary rules as well. And they include competence, the scope of representation, communication, fees, confidentiality, conflicts of interest, safekeeping property, and file management. Of those, we're going to focus on scope of representation, communication, and to a certain extent, file management and return. But I do want to mention at this point the idea of confidentiality, because there will be questions and answers. If you're asking a question, please keep it general. Please don't mention a client name or, in fact, anybody's name, because as a lawyer, your obligation of confidentiality extends to the very fact that you have a client. Obviously, that confidentiality is waived when you file a pleading in someone's name or something like that. But until there's a public requirement that you disclose it, even the names of your clients are confidential. So be careful when you're asking questions. I'll try to be careful when I'm giving you answers, that we don't infringe on anyone's confidentiality. I would also remind you in that regard that your questions, my answers, and indeed this whole presentation are not legal advice about any specific matter. We're going to be talking in generalities. We do not have an attorney-client relationship. We're keeping it general because we, and I mean both you and I, do not want to find ourselves in a position where we've undertaken obligations that we don't intend to fulfill. Now, these are the ABA model rules, but beyond the model rules, there are professionalism guidelines in most jurisdictions, including the federal courts. These guidelines are aspirational. They are enforced generally only by peer pressure. In most cases, they are specifically not enforceable by the courts. Many states require that their local guidelines be attached to fee agreements because they want clients to understand what constrains the lawyer in terms of professional conduct. And many courts require that lawyers appearing before them subscribe to that particular court's or a local bar association's standards of conduct. I've appeared pro hoc vice in, many federal courts across the country. In every case, I was required as a pro hoc vice lawyer to subscribe to the court's local code of professionalism or code of conduct, even though I was not a permanent member of that court. So courts may not enforce these through legal means, but courts do take them very seriously, and that means we should take them seriously as well. I will say our practice at Hunt Huey is we attach the Texas rules of professional conduct, which are non-binding, but we attach them to our fee agreements because they do help us explain to our clients the things that we're not going to do. So, setting the stage for good client relations. Look at ABA Model Rule 2, 1.2, and the first thing is scope of representation. It is easy for clients to be disappointed when their lawyers don't do things that they thought their lawyers were going to do for them. Some of these things are obvious. Most of you probably have a fee agreement that says you don't give tax advice unless you're a tax lawyer, or that you don't record deeds if you're a real estate lawyer. So the tax advice in particular is one of those things that, because so many parts of a legal practice have tax implications, we need to make sure our clients do not think that we're advising them on those tax implications. But there are other things as well. If you are hired for a particular real estate transaction, your fee agreement should describe the transaction and note that your representation is limited to that transaction. If you're in a litigation matter, your fee agreement should name the litigation matter and describe the scope of your representation. I've worked occasionally with employment lawyers whose fee agreement reminds their clients that they do not do trial work. They have been hired only to file a complaint with the EEOC and negotiate a settlement, and a separate fee agreement is required for trial. They've learned to do that because clients would think, well, I've hired a lawyer, and therefore I've hired a lawyer for every problem I have from now to the end of time. That leads to disappointed clients. Disappointed clients lead to grievances with state bars. You want to avoid that. So the best way to start your representation off is to make sure you and your client understand exactly what the scope of your representation is. At the same time, when you're bringing in a client, you need to look for personality types that may represent a difficult client or that may require special handling. You need to anticipate behavior. Clients that behave badly in front of you are likely to behave badly in front of a judge or a jury or an opponent in a transaction. You should be aware of that in advance so you can try to deal with it. And of course, when clients behave inappropriately, you may have to take a range of actions. If they're behaving inappropriately with others in court or in a transaction, of course, you can simply explain to them why that's probably not a good thing to do. Maybe their own self-interest will drive them. If they're behaving inappropriately with you or with your colleagues in your firm, you may actually have to just quit, because clients who cannot moderate their behavior to live up to either professional or just plain social norms are always going to be clients that are problems in another way. One way to make sure that your clients understand their obligations and yours is to explain the professional boundaries that they are under and that you are under at the very start. Here are some examples of things that we talk about with our clients. You don't need to say every one of these to every client. Some clients will be able to tell when you first visit with them that it's not going to be a problem. Sophisticated, high-level corporate counsel are less likely to expect you to engage in unethical behavior. I only say less likely. It's not impossible. Individual clients may be more likely to have formed all their opinions about how lawyers act from watching TV shows. And if that's where their opinions about how lawyers act come from, then they may have some misconceptions. They may also have opinions about what lawyers do based on watching lawyers who hold press conferences on the courthouse steps. Whether a press conference can be held on the courthouse steps and what you can say at such a press conference is pretty well constrained by the disciplinary rules, either the ABA model rules or the rules in your jurisdiction. But lots of lawyers ignore them, and the lawyers who ignore them are often on TV and therefore may strike your clients as the model you should follow. So make sure your clients understand that you can be effective. In fact, you can be more effective if you don't engage in bullying or yelling or whatever. Let your clients know that you cannot just say you're going to win at all costs. You can't play games with evidence. You can't assist with crimes and frauds. That's fairly obvious. But you also won't help them lie to the tribunal, because these are all both ethical and professional obligations that you are limited by and that your clients need to understand you're limited by. And I have had a few occasions in the last 40 years of practice where I've simply had to tell a new client, even a good new client, that they needed a different lawyer to represent them because I wasn't going to be willing to do what they wanted their lawyer to do. And I think in almost every case, it was a good decision, because I didn't make money, but I did avoid a lot of grief. That's scope of representation and of what lawyers can expect from us in terms of our professional conduct. We also need to talk about client communications. And communication is intimately tied in with scope of representation. ABA Model Rule 1.4 sets minimum standards for communication with our clients. But you should also set your clients' expectations when they come in for the first time. Lawyers who have a high volume practice of one kind or another, personal injury practice, for example, probably need to make sure their clients understand that they will not get a daily phone call from the lawyer keeping them up to date, because that's not the nature of the practice. We do represent, and as ethics lawyers, we do represent personal injury lawyers from time to time, and communication is a constant problem because the clients get used to the idea or come in with the idea that they are going to talk to their lawyer a lot, when the practice may be set up for practical reasons to mean that they'll talk to legal assistants a lot. So client expectations need to be set, but at the same time, you can't set a client expectation that is just, we won't talk to you. Your ethical obligation to communicate with your clients means that you are going to have to stay in touch with them as your strategy changes through the course of a lawsuit or even through the course of a transaction. You need to make sure that they understand that the strategy is changing. If there are trial and hearing dates, they need to know about those as soon as you know about them, even if their presence isn't required, because they're entitled to know that something's going to happen that they should know about. And of course, they're entitled to know about the outcome of hearing. So set client expectations, but make sure that your expectation is that you will communicate with your clients so that at regular intervals they understand what's going on in their case. And that will also cut off random calls where they ask you what's going on in their case. Here's a to-do list that can help with communication problems. First, give the client in advance frequently asked questions type document that explains what you are and what you are not going to communicate with them about and what their expectations should be. Make sure that you have a system in place to share routine updates with the client. Even if nothing's happening, you should tell your clients nothing's happening so that they understand that because of the circumstances, nothing is going to happen. It doesn't mean you're not working. It just means that your case is in a place where nothing's going to happen. I often tell my clients, in litigation, you should realize we have gone into litigation time, which is what happens when the hands of the clock move about 1/10 as fast as you would expect them to move, and the months on the calendar never seem to change, because that's what a lot of litigation is like, right until the end when it gets very compressed and in a hurry. If there are issues to communication, you need to address them in advance. Make sure your clients understand that they need to let you know if their phone number changes or their email changes or their address changes, so that you will be able to stay in touch with them. And also, because you want clients, most of you at least, want clients to repeat, actively seek their feedback. Make sure that they understand that you want to know what they need in terms of communication. And that way they'll be more satisfied with your communications because they feel like they've had input. And finally, maintain transparent billing practices. We don't usually think of billing as a form of communication, but the invoice you send a client or the reconciliation you send a client on a contingent fee matter is a form of communication. And if the client doesn't understand that communication, they're going to be unhappy with the amount that they have to pay you. Invoices are preferably detailed, so the client can see the work that they're paying for. One practice, this is my practice, is to make sure my clients get a copy of everything that I sent. Emails, letters, and of course, pleadings and other court papers. So they understand when they get a bill what I've been doing for them. So billing transparency is very important. And as a side benefit, in most actions where you're seeking to recover attorney's fees, you're going to need that kind of detail anyway for the court. So you're only doing something that will help you in advance. Our next subject about difficult clients is withdrawal. We all hate to withdraw from representing a client. Partly it's going to be because we hate losing a case. And in some sense, when you have to withdraw from litigation, you've lost because you no longer have the opportunity to win. So we hate to do that. We also hate to withdraw because there's always a feeling in the back of your mind that although the client isn't paying their bills now, that when you win, they are going to be happy and pay fully. And of course, withdrawing usually means that you are giving up whatever amount of fees has not been paid. It doesn't legally mean you're giving up those fees. Obviously, the client has a contractual obligation to pay for your work, but I was told many years ago, and my experience has borne it out, that the best way to have a grievance filed against you as a lawyer or to have a malpractice claim filed against you as a lawyer is to file a lawsuit to collect a fee. So you don't want to have to file a lawsuit to collect the fee, and you understand that withdrawal might make you have to do that. So there's a tendency to hang in a little longer than we should. So repeated non-payment is a problem. You also have to be alert to dishonesty by your client, either explicit dishonesty when you find out they're just not telling you the truth, or dishonesty in the form of simple non-responsiveness. And of course, you have a right to have your clients treat you with the same respect you would treat them. Clients who are abusive to their lawyers are clients that you need to withdraw from. And this isn't just a matter of your personal dignity or how you feel. It's a matter of professional competence, because it stands to reason that if a client is abusive, if a client is bullying, if a client is making demands that you know you can't fulfill and then they're complaining about it, your own attitude toward the client is bound to infect the way you represent them. And so to fulfill your professional obligation, you need to get out of that bad situation. And of course, threats or hostility, you've got to get out of that. Clients who are a threat, as soon as a client threatens you, in fact, you have a conflict of interest. The first time a client says, I'm going to sue you, or I'm going to file a grievance, or even I'm going to call the senior partner and tell him about this problem, then that client has created a conflict of interest, because your interest is to avoid the grievance, to avoid the conflict, to prove that what you did was right, and that's not the same as the client's interest. So threats or hostility will mean a necessity of withdrawal. You have to do things right when you withdraw, and this is always difficult. Model Rule 1.16d has the duties of a lawyer on withdrawal. The main one is to make sure that you take steps to protect the client's interests, and that means reasonable notice, turning the file over, refunding advance payments that have not been earned. Now, these are all things that are a little bit difficult to do, particularly when you're withdrawing under bad circumstances, such as you have not been paid. The last thing you're interested in doing is spending more of your time not getting paid for it to protect your client's interests. The time it takes to assemble the client's file and return it to them just seems like another thing that you're not going to get paid for. And by the way, it is something that you ethically cannot charge for. And of course, you're in a good position if you have been paid more than you have earned and you have to refund in advance. But it's always a little difficult to take money even out of your IOLTA trust account and give it back to the client. We have some formal opinions about this. I'm not going to read them to you, but they all discuss this duty to protect the client, to communicate with the client, and to return the client's file. Issues often come up about the client's file and what should and should not be in the file. We're going to talk about some specifics there with this next slide. So, withdrawal is imminent. Even before you undertake a representation, of course, you need to know what the local court rules concerning withdrawal are. In Dallas County, for example, a motion to withdraw either has to be signed as agreed by the client or contain an explanation of why the client hasn't agreed. Many courts have similar requirements, so make sure you know what you have to do to satisfy the court when you're getting out. You need to make sure you memorialize your discussions with the client in writing. This is just covering yourself, because as soon as you know you're withdrawing, even under the best circumstances, even when the client has cheerfully said they're just found another lawyer they like better and they're your pal, nonetheless, you need to make sure that you're covering yourself with respect to fulfilling your obligations. Make sure the client knows the key deadlines, give them a status report, send them an up-to-the-minute final invoice so that they understand their financial obligations. Refund any unused retainer as soon as possible. And as soon as possible generally means about the time it takes to write a check and put it in the mail, which is not very long. So you can't hold on to client retainers. Tell opposing counsel you're withdrawing. You'll usually have to, in some cases, you'll have to confer with them before you file a motion to withdraw. But in any case, you need to let them know as a courtesy. And then make sure if you are withdrawing that you've at least tried to refer the client to other counsel or to a local bar association that may find counsel for them, so that at the end of the day, the record will show, and I mean a written record will show, that you did everything you could under difficult circumstances to protect your client's interest. It's worth talking about voluntary and involuntary withdrawals because there are situations in which withdrawal is mandatory. If the continued representation would violate legal ethics, if the lawyer is impaired, usually most impaired lawyers don't recognize that they're impaired. But for example, a lawyer who is physically ill and realizes that they are not up to the stress of a representation should just go ahead and withdraw. And of course, if the client fires you, you have to withdraw. You can't oppose being fired by your client because they do have an absolute right to choose their attorney. So you may be forced under some circumstances to withdraw. I will say the most common circumstance I've seen over my career is because the firm hired someone and created a conflict that could not be waived or could not be Chinese walled around. And not all jurisdictions permit the Chinese wall. So sometimes representation is terminated for that kind of conflict. In fact, I think that's the mandatory withdrawal is almost usually because of that kind of conflict. But in any case, whether it's mandatory or voluntary, you want to make sure it's well documented. And one reason you want to make sure it's well documented and that you gave the client plenty of advance warning, and most important, that you did it promptly when you saw that problems were developing that couldn't be solved. And that is, the judge always has the last word. In litigation, the court is not obligated to allow you to withdraw as someone's counsel. And I have seen many times lawyers who decided a few weeks before trial that their bill was never going to get paid on time decide that that was the time to withdraw, and found that a local judge who was not going to delay the trial for another 6 months because of a change in counsel simply said, well, you didn't start soon enough. You're going to have to finish this case. And even if it's not a trial, it's very likely that if there are imminent hearings coming up or that there are deadlines that it would be very difficult for a new lawyer to meet, that the judge might require that you stay on the case until those deadlines are met. In other words, until the position of the client is such that they would not be prejudiced by your withdrawal. And of course, you would like for the judge to recognize the problems you have that are making you withdraw, but because of your duty of client confidentiality, you are probably not going to be able to tell the judge anything or very much about exactly why you're withdrawing. So you may have had a knockdown, drag-out fight with your client in the conference room, and they may be 6 months behind on their bills. But those are matters that you're not going to be able to put in your motion to withdraw in most cases, because putting that into the public record would violate your duty of client confidentiality. So if you're withdrawing, withdraw early so that you'll have time to wrap it up in a way that makes the judge happy with letting you out of the case. So that's difficult clients. Now we're going to talk about difficult lawyers, which is really what most people think about in terms of civility and professionalism, is the difficulties lawyers have with each other. What's a difficult lawyer? Well, someone who doesn't follow the rules, obviously. Someone who uses hyper-aggressive litigation tactics. This often comes up in conduct during depositions, for example, when the lawyer is bullying or abusive. There's general uncivil behavior, which we see some of, and then a failure to extend professional courtesies. And this is professional courtesy is sort of an old-fashioned concept, but I will say one of the first lessons I learned from an opposing lawyer was what your opponent asks from you in terms of an extension of time or something of that sort, you're eventually going to need to ask from them, or if not from them, from another lawyer who may have heard about it. So professional courtesy is not a weakness. Professional courtesy is a way of ensuring that you are best able to represent your client because you have an appropriate reputation in the legal community and with the courts. And frankly, I think there's probably nothing that judges like less than having to rule on a motion for a 30-day extension to respond to discovery, because it will seem to most judges like that is something the lawyers should not have wasted their time on. And of course, we have certificate of conference rules now that many judges take very seriously. And if you have not substantively conferred about some minor disagreement that should be resolved among the lawyers, the judge will often punish one or both lawyers for failing to do what they should do. And the reason judges take this seriously, and the reason you should take it seriously, is because especially public displays of unprofessional conduct are a threat to the judicial system. Our system of justice rests ultimately on public trust. The courts only work because people believe that more or less they will get a just result if they take their problems to court. When there's widespread public mistrust of the judicial system, the courts can't work effectively. And, by the way, lawyers won't get as much work, because when people turn to other methods of resolving their disputes besides the courts, they frequently don't need a lawyer. Equally important, advocacy, effective advocacy, requires professionalism, because you can't effectively advocate for your client if you have turned the opposing counsel into your implacable enemy through some sort of rudeness or discourtesy, or even they've formed an opinion that you're not a reliable person. Once you've poisoned your relationship with a judge or an opposing lawyer, your ability to represent your client has been diminished. And that gets back to, by the way, something we'd have to explain to our clients when they expect to see us come out breathing fire, is that, one, the other lawyer is not their enemy, and second, our ability to be effective advocates depends to a certain extent on our ability to get along with each other. There are rules in the disciplinary rules about professional courtesy, or what you might call professional courtesy. We are not to advance unmeritorious claims. We are to work to expedite litigation, to ensure the just and speedy resolution of claims, which is something you'll find at the beginning of most rules of civil procedure. We are obligated to be honest with the courts, and judges really hate it when they find out you're not honest with them. We are to be fair to others. Trial publicity, as I said earlier, is constrained by any number of rules. And we also have to be fair to third parties. So, and then finally, we have this, that I call it the catch-all, prejudicial to the administration of justice. Being a jerk, acting like a jerk, harms the justice system, as I said before. Now, are these important issues? As I said, there's the tendency to say in the good old days, things were better. Whether that's true or not, and I don't think it was ever true, there is widespread belief that incivility among lawyers harms public and client trust. It prolongs case resolution and therefore makes cases more expensive, and it reduces satisfaction with the outcome. Usually the loser is not satisfied in a lawsuit, or at least they're not happy, but the loser should at least leave the lawsuit believing that they got a fair shot. Now, they'll probably blame their lawyer. They'll probably blame their subordinates if they have subordinates. If they don't, they may blame their dog. Who knows? They'll blame somebody because they're unhappy, but they shouldn't think that the whole justice system is unfair. And they shouldn't focus their anger on you if you're the opposing lawyer and simply blame you for their conduct. Because once again, as a practical matter, grievances are mostly filed by clients, but they can be filed by opposing parties as well. And lawyers who really display bad behavior may find themselves at the wrong end of a grievance by an opponent. And no matter what they think about that grievance, it's at least going to be an expense and an inconvenience. Most of this conversation has been about opposing counsel. Unfortunately, sometimes our colleagues are not perfect either. You see here the results of a survey about common forms of bullying behavior. These mostly came in the context of a firm that had at least multiple lawyers, usually larger firms. And that's because, of course, first, lawyers are people, and some of them are not as nice as others. Bullying behavior also comes because there is inherent in most big firm structures, and I'll say I spent most of my career working in firms with between 80 and 400 or 500 lawyers, but there's always competition within a firm as well. There's competition between lawyers, competition for good cases, competition for the attention of the boss, and competition leads people to behave badly in some cases. What can you do about bullying behavior? And this is going to be a question that's mostly addressed to the objects of those behaviors, I should say, which is typically younger lawyers. Sometimes lawyers who are women, because we have not yet reached a place where we've overcome certain sexist attitudes. But in any case, the objects of bullying are in a hard position because the bullying may be coming from people that are superior to them or about whom they cannot do anything. The next slide is for those of you who aren't in that position. That is, those of you who are sufficiently important or powerful, however you want to call it, within your firm to have some influence on what the firm does. And that is, there is a firm level response to bullying that any firm of any real size should have. One, it has to have a policy, an anti-bullying and anti-harassment policy. That's important for bullying, but it's also important because it is extremely easy for bullying behavior to turn into behavior that is discriminatory based on race or some other suspicious classification. And so a firm, you don't want bullying for any reason, but you certainly don't want bullying that is interpreted as a violation of the anti-discrimination laws. You need training and bystander tools so that people who see bullying but aren't directly affected by it know that they can report it. And as it says here, a method for safe reporting and non-retaliation. These are all hard things to implement in what we like to think of as a collegial atmosphere where everybody's working together for the best interest of their clients. But they are important because any significantly sized group of people is going to have some people who are not nice and who engage in bullying, and you need to have a way to deal with it. Turning back to civility in general, we all took an oath of civility. When you take your state's attorney oath, you are bound to professional obligations that may not specifically include civility as such or professionalism as such, but as we've seen in the ABA model rules, includes any number of rules about how we treat other people that are, in fact, overlap at least with civility and professionalism. If you're in federal court and you've taken an oath to be a federal, to practice before the federal courts, you have to conduct yourself with integrity and civility. That's part of the oath. So almost everyone who's watching this has taken an oath that requires either more or less explicitly that we behave civilly toward other lawyers. And so I say that because that means it's a serious obligation. A lot of lawyers kind of roll their eyes when we talk about civility and professionalism because they're driven by the rules, and they say, well, show me rule, show me rule. It's there probably in the oath you took, and it's at least implicit in a lot of the disciplinary rules of professional conduct. Of course, in addition to those rules, we do have guidelines, professionalism guidelines in many courts that, as I said earlier, may be required for all lawyers to subscribe to. Some cases, they have to be attached to a fee agreement, but you have to take them seriously because other lawyers take them seriously and judges take them seriously. The judge who cannot directly sanction you for uncivil behavior is always going to have the power to indirectly sanction you by simply taking your arguments less seriously, assuming that your client's own conduct is reflected in your conduct so that your bad behavior gets imputed to your client as well. The immediate consequences of incivility are frequently a rush of endorphins in it, and that good feeling you get when you've just been allowed to fully express your emotions. But the long-term consequences are not going to be good, either for you professionally or for your clients. The big picture. Our profession relies on ethical and professional conduct. Many of you will be aware that in some states, including Texas recently, there have been efforts to simply dismantle the Bar Association as essentially a monopoly on the ability to practice law before the courts. And those efforts frequently stem from the feeling that what lawyers bring to the table in terms of justice is what you might call TV lawyer behavior, abusive behavior, bullying behavior, covering up the truth, not working to achieve the ends of justice. So when the bar is under attack because of the behavior of lawyers, and I hope it's not you, but then we're all under attack, and our profession is under attack. We do have a special privilege as attorneys. We get to stand before the bar, an old-fashioned phrase that comes from which we get the word barrister in England. But there is that bar between the people who are watching the trial and the people who are conducting the trial. And our license to practice law is a license to stand on the right side of that bar. So it's a privilege that we have to live up to. This slide is slightly redundant because you will all recognize this kind of behavior. I want to say one thing about it because I look at this list and I see some behaviors that I have engaged in. it is hard not to occasionally make a snide remark in front of a judge or in front of a jury. Lying to the court's easier to avoid, as are threats of violence, but certainly being rude is all too tempting when we're in a hurry or when we're in a bad mood. Every once in a while, we'll feel pressure from our clients to engage in behavior we know is unprofessional. I mentioned that because I think that sort of overlying our discussion of civility has to be a willingness to distinguish between bad lawyers and lawyers having a bad day. When the courts in the Northern District of Texas, almost 30 years ago now, adopted a set of guidelines for professional conduct, one of the first things that happened was lawyers started filing sanctions motions based on failure to follow the guidelines, and then the guidelines had to be revised to say these aren't supposed to be a tool for beating up other lawyers. And we need to understand that as well. Our relationship with opposing counsel and opposing parties is not always going to be ideal. And they are probably going to do some things that we don't like. We may do some things that they don't like. And as we go along, part of professionalism is going to be recognizing, is this a problem that really deserves the attention of the court? Is this a problem that deserves some kind of big discussion between the lawyers? Or is this a problem that isn't going to happen again, and I should just ignore it and let it go by and see if it doesn't get worse? Because, of course, frequently when we engage in battles with our opposing counsel over things that are not directly related to advancing our client's claims, we're wasting our client's money. So dealing with bad behavior, be prepared. This articulate your problem to the offender. Document your conversations. Well, articulate your problem to the offender. Once again, this requires a little sensitivity. Telling somebody that they have made you mad is not always the best way to not make them madder. So think first before you discuss your problem with the offender about whether discussing the problem is only going to make it worse. What you can do, however, to protect yourself is document your conversations. If it's legal to do so and you realize you have a problem with opposing counsel, record your conversations. Limit your communications to email. If you find that opposing counsel is abusive in telephone calls or the like, have another person present. This is frequently helpful with intra-firm bullying. Last, you can tell an authority figure, that's a judge or a boss, about the problem if you think it rises to that level, and if you think telling the authority figure is the best way to advance your client's interests. And we're going to keep getting back to that because, of course, as lawyers, our job is to advance our client's interest. And the fact that something has made us mad does not necessarily mean that complaining about it is a good thing for our client. And finally, call the lawyer assistance program. A lot of bad behavior, especially what you might interpret as rudeness in terms of like failure to answer calls, failure to respond to emails and so forth, may be a symptom of impairment. Calling lawyer assistance is not something to be done lightly at all. But if you become convinced that another lawyer you know is impaired in some way, then you do have an ethical obligation to notify the bar through the appropriate program. And you'll have to trust that the bar will handle it with sufficient sensitivity. So it's not common. I think in my career, I've had multiple lawyers that I dealt with that I was convinced had some sort of impairment. I've only had one case where I felt like their impairment was affecting their ability to practice law to the extent the bar needed to know about it. But If you're convinced that your opposing counsel is impaired, you need to report them. Staying civil when someone else is not. Well, this is key. Don't get emotional. Oh, that's so easy when someone's yelling at you. Just remember, though, it isn't personal. Most bullies are all-round bullies. They bully everybody. You should be prepared for it. You should always be wearing the white hat. The fact that your opponent doesn't follow the rules doesn't mean you shouldn't follow the rules. Don't retaliate, because doing a bad thing in response to a bad thing leaves you in a position where you can no longer complain about the bad thing because you just did it yourself. And then, if necessary, create clear boundaries. You can say to opposing counsel, I will not talk to you on the phone. You must send me an email because of the way you've behaved. And if they go complain to the court, then you'll get to explain to the judge why you had to set that boundary. But above all, try to set aside your own emotions and think of the best rational way to respond to this behavior in the way that is best for you and your client, as opposed to your immediate emotional needs. With the courtroom, you need to make sure the judge understands that you are cooperative. Judges view cooperation among lawyers as a way of helping the court do its job better. When lawyers don't cooperate, it forces the courts to work harder. So the judges need to understand that you're being cooperative and trying to advance the ball in the way the judge understands. If you find out that you've done something that wasn't understood, try to correct it. And number 3, don't weaponize objections or motions to disqualify. Judges hate it when you file a motion of some kind that has relatively little merit and it's clearly being used as a litigation tactic. It will almost always backfire. So while it's very tempting, you should not rush to court unless you feel you really need to, particularly with motions to disqualify. You should give the other lawyer at least a chance to withdraw with a good explanation to them of why they should withdraw before you go to court, because you want to avoid looking like a lawyer who is weaponizing these tools. The same with motions to compel and motions for sanctions. I learned a valuable lesson from a bankruptcy judge relatively early in my career when the opposing lawyer did something that was very clearly wrong and very clearly sanctionable, and I filed a motion for sanctions. And the judge did award a sanction. He said that the conduct was sanctionable. He ordered the opposing counsel to donate $100 to charity. And he told me that since he already knew about the lawyer's misconduct, that my motion had really just wasted his time. So who came out the loser? Well, my opposing counsel was out $100, but I had a judge who didn't like me that much anymore. So finally, active wellness or active witness be the change. Our own good behavior can be an example to other lawyers. Lawyers who are my age or approaching it have an opportunity to be an example to younger lawyers and to show that you can succeed without being a jerk, without being a bully, without trying to bend the rules or be dishonest in any way. In fact, you can win with the truth. That's one of our firm's precepts, winning with the truth. It should be possible if you're a really good lawyer. But also be willing to seek outside help if you really need to. Particularly younger lawyers should not be shy about looking at least for advice from other lawyers before they take action that might be too extreme for the circumstances. That pretty much wraps it up. I want to make sure you understand who we are. I'm Hunt. My partner is Jean Huey, is on the right. She is, in fact, a specialist in legal ethics. And although our firm represents lawyers in disciplinary proceedings and other ethical proceedings. She is pulling the laboring oar on that part of our practice. And as you can see, we're fully trustworthy because we have professional headshots. Thank you very much for your time, and I'm going to let Nina tell us if there are any questions.
Thank you so much, Richard, for that insightful presentation and taking the time to be with us today. As Richard mentioned, we can now move into questions. So if you've got a question, you can go ahead and submit it by clicking the Q&A button and sending in your question there. I've already got a couple, Richard, so I'll go ahead and go through them. The first one comes from the Next. They share, sometimes my biggest problem is when I email a judicial assistant for a proposed order, hearing date, etc., and my opposing counsel replies and reprimands me, copying the judicial assistant and lying in the email. She says, I normally ignore it, but I know we shouldn't argue back and forth. Have you had an experience like this? How would you recommend handling when this comes up?
Yes, I've had this experience a few times. And I've generally found that the best way to handle it was actually to trust that the court's employee, whether it was a law clerk or a courtroom deputy, is frequently involved in these things, or the court secretary, they've usually seen this enough that they understand that the business part of their job is to look at the original request and either set a hearing or not set a hearing, but they will only regard the bad behavior by the lawyer as bad behavior by the lawyer. Now, I think if the lawyer simply lies about something in their responsive email that's going to the court, you probably have to correct that lie. The court deserves to know what the truth is. But if it's just rudeness, I think the best thing is to leave it alone and let the rudeness speak for itself.
Thank you for that insight, Richard. Our next question is, what do you think is the best way to handle a client who keeps pushing you to take unethical shortcuts, like misrepresenting facts in negotiations?
Well, there's two steps here. First, you should explain to the client that you can't do it, but more important, that it is not in their interest to do it. Because if it's a business transaction, the client should understand that in the course of their career as a business person, if they become untrustworthy, it will hurt their ability to do things that they want to do. Of course, if it's in litigation, I think it's helpful to tell clients that because we have an adversary system, we have somebody on the opposite side of this case who is a trained professional whose job is to find out everything that was untrue and report it to the court. So when you engage in that kind of misrepresentation in judicial proceedings, you've got a judge who won't like it, but more importantly, you've got somebody who's being paid to figure it out and report it to the judge. So it's just not a good idea to do so. And of course, even for relatively minor things, once a client is perceived by the judge to be dishonest, then that client is at a permanent disadvantage. And if you, as their lawyer, are perceived by the judge to be dishonest, then you are at a permanent disadvantage as well, and you can't do as good a job for them. I was told early in my career that the job of the lawyer is to be a reliable guide for the court and ultimately for a jury, a reliable guide to the truth. And you can tell your client, if you lose that reputation for being reliable, then the main person that will suffer in their case is them.
Thank you, Richard. Our next question is, how should you respond when opposing counsel is openly hostile or uses intimidation tactics during communications?
That's a good question. And The easiest thing to say about that is, well, you should just ignore them and pretend that they're not doing this. That's very hard to do. Okay. It's hard for me to do after I've been practicing law for more than 40 years. I think for younger lawyers, it's especially difficult to do, and particularly if your opposing counsel perhaps has more experience or is older and is therefore finds it easier to be intimidating. So the response of just ignore it probably won't work. The other obvious response, which is to respond in kind, is also ineffective. Because lawyers who engage in those tactics will not be threatened or scared off by you engaging in those tactics, because that's not their personality. If that was their personality, they wouldn't do this stuff in the first place. So what you have to do is do your best to restrain yourself while recognizing that you need to make a record of their conduct in some way, so that you can use that record later if you need it. If this is yelling at you on the phone, a good strategy is to hang up, frankly, and say, send me an email, and hang up, because they will not be that abusive when it's written. If it's a situation where you can't just hang up on them, then at least at the end of the conversation, discussion, or whatever it is, make a memo to your own file, contemporaneously explaining what happened and how it happened. But if you can, ignore it and proceed as if it weren't happening. That's hard. But do not respond in kind.
Thank you for that insight, Richard. Our next question is there a point where a client's behavior becomes so unreasonable that it justifies withdrawing, even if it might harm the client's case? If so, what would you say that is, in your opinion?
I think there is a point where you have to withdraw because the client is simply not going to behave in a way that lets you fulfill your professional responsibilities. If a client is determined to lie to the court or to a jury, for example, you don't have any choice but to withdraw. Now, first, of course, you'll tell your client, look, if you lie to the court, I'm going to tell the court you're lying because I have a professional obligation to do so, and that's going to be bad for you. But the other thing is, if you lie after I tell the court you're lying, I'm going to withdraw as your lawyer. And that's probably going to be bad for you as well. For clients like that, I would not be concerned that my withdrawal is going to hurt them. And the reason is because although I have a gigantic ego, I'm reasonably confident that any client of mine could, if they looked around, find a lawyer just as good as me, but maybe with fewer constraints on their ethical behavior. So the client will find another lawyer. You shouldn't worry about that. And if it's simply a situation where withdrawal would come at a point where it's hard for the client not to be prejudiced, trials coming up in a week, whatever, I think your first answer to yourself about how can I withdraw under these circumstances is simply the client will be worse off. And I'm talking about a client that's going to lie to the tribunal. They will be worse off when they lie and I turn them in than if I withdraw and they get to lie on their own. So, but if a client insists on lying, then I don't think you have a choice but to withdraw. And if they don't like it, you can explain to them that the next thing you're going to do is you're going to tell the court, and that's going to be worse. So.
Thank you, Richard. And then our last question for today, and thank you again for staying a little bit over time, is how can lawyers document any unprofessional behavior from opposing counsel without escalating the situation or appearing combative?
Well, so you can, you don't have to get out your phone and take video of the conversation. That would probably be a bad idea. But you can certainly, you can do two things. If it's unmanageably abusive, you can simply terminate it. You just walk away, hang up the phone. Second, if you can manage the situation to at least complete whatever business you're going in, then you can make a memo to your file that explains what the conduct was. Make it contemporaneously because you may have to use it later. From the question, I think the person asking has sensed that sending an email saying what a jerk you were is probably not going to be helpful. The best thing to do, and this is simplistic, but it's still the best thing to do, is to remember, is to ask, what can I do that will best serve my client's interests in this case? Because a lot of times, abusive behavior doesn't hurt by the other lawyer, abusive behavior doesn't hurt your client, it just hurts you. And so it's unfortunate that it hurts you, and you can take steps, reasonable steps to take care of that if you have to with the court. But it may be that you just have to put up with some of it if that's in your client's best interest.
Yeah. Thank you so much, Richard, for all of your insights, answering our audience questions, and just being here with us today. We really appreciate it. And thank you to all of our audience members who submitted questions. We always appreciate your participation. It really helps us make our presentations even more engaging. So thank you so much. As a Justia Connect Pro, you'll get access to additional benefits like an enhanced directory profile with the Pro badge, no competitor ads. You will also get access to our AI-powered Justia chat to help you boost your leads, and $200 off of select Justia marketing solutions. You'll also find the link to upgrade or learn more, pro.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks again. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.